everybody. We are back today for another legal insight, and we have our lovely Mr. Brett Woodburn joining us. How are you today, Brett?
I'm good, Nick. How are you?
I'm great. Thanks for asking.
Yeah.
It's a little weird, our first time without Heather. As you guys know from our previous announcement, Heather's little sabbatical, and her presence is definitely missed. Um, but let's go ahead and dive in here today, Brett. So, we are still coming off of changes to the industry, changes to how business is conducted. One of those, primary changes is compensation. And with that, we touched on Article 3. We can link that video here for you guys to find that as well. But now, coming off of Article 3, and we anticipated some changes and stuff. But let's take a deep dive into the cooperating broker form that we have from PAR. And there's other ones out there that are floating. And let's talk a little bit deeper into what a cooperating fee is, does, shouldn't do, should do kind of thing.
There's a lot there to unpack on some levels, and on other levels, it's pretty straightforward. Uh, I think this is one of the areas where the change as a result of the settlement and removing Office of Compensation from the MLS is, falling into the law of unintended consequences. The impact and the effect that it's having on realtors is requiring them to think of things that they never had to think of before when the Office of Compensation were in the MLS. So what I mean by that is, when you had an offer of compensation in the MLS, it was a unilateral offer. The MLS constructed the paradigm, the rules that made it very clear when I put an offer in and I'm offering a fee to a broker that's showing the property, that fee is made to everyone. And what do you need to do in order to earn the fee? Well, it was defined through the rules of the MLS. But in one way to look at it is if I'm representing a buyer who presents, it's a ready, willing, and able buyer who presents an offer with terms acceptable to seller, contingencies are satisfied, and we're ready to close, I've earned the fee. And when it was offered in the MLS, you as an agent didn't really need to think much past that. So you weren't negotiating typically fees. Not that it never happened. It just wasn't the common practice, at least not in central Pennsylvania. I know that there have been areas in Pennsylvania where the cooperating broker compensation agreement was used regularly, particularly in the Southeast, for different reasons than establishing compensation. It was more for confirming compensation. And some have said, although I'm not sure it actually was intended to work this way, to resolve any future concerns about procuring cause. So now, if you're still operating under a paradigm, if your brokerage is still working in a way where you as a buyer's broker are looking for or going to request that the listing broker pay you a portion, some or all of your fee, and you now have to negotiate that fee. And in negotiating fees, we've got to think about the ethical considerations that go with that. Things that were addressed and covered under the way the MLS was structured. And one area, then there are a number of different articles and standards of practice that are implicated, but two of the main ones are Article 3 and Article 16. And Article 16 is the easier of the two to deal with because it tracked nicely with the MLS requirements. And Article 16 says, 16-16, the standard practice, basically says you can't use the terms of an offer to try to negotiate your fee, or more importantly, to try to force the listing broker to modify their listing contract.
Yep.
Right? Because if I have a listing contract that says I'm authorized to pay you X percent, and you want Y percent higher than X, 1616 stopped you from requiring me to pay you. So you could not put in an agreement of sale that you know, Woodburn Realty will pay Howard Hanna 15%
Yeah.
when the MLS said something less than 15%. You could always put in there that the seller could pay the compensation. So now we have a situation where we no longer have a unilateral offer of compensation. Under Article 3, it says that it makes very clear that cooperation, which is required unless not in the seller's best interest, is very different and distinct from compensation.
Correct.
But it also says that a realtor is obligated to ascertain what the compensation is before they begin to accept the offer of cooperation. And I
Mhm.
don't know of any realtor that actually thinks about it that way. In other words, you still have a duty to cooperate under the Code of Ethics and in the MLS. I have 25 years of doing this. I've never heard a realtor state when I put an offer in the MLS, it's an offer to cooperate with other brokers. I've never heard that. And I've
Yeah.
never, and I don't know that any buyer's agent has ever thought about it that way. So if it's an offer to cooperate, the Code of Ethics says standard practice 3-1, I think, says as a buyer broker, you have to determine if there's any offer of compensation before you start to accept the offer to cooperate.
Yep.
So when it's in the MLS, when the offer's in the MLS, we've got all those dynamics. Now that it's out, offers of compensation aren't in the MLS. Now, does this mean that there is no offer of compensation at all with the offer to cooperate? Meaning, by putting it in the MLS, does that mean that the standard practice 3-1 is no longer relevant? It doesn't apply.
Correct.
So it's a great question because I could certainly argue that 3-1 doesn't apply anymore because there's no offer of compensation. If you put, Nick, on your website for all of your properties, if you put on there that let's say all of your, for purposes of this discussion, all of your sellers agree that they're going to authorize you to
To
offer
offer.
X%,
Mm-hmm.
and you put it on your website, all these properties are willing to offer X%.
Mm-hmm.
Is that a unilateral offer of compensation? And I think the knee-jerk reaction would be to say yes, because it's just like the MLS. But I'm not sure that yes is the right answer, because within the MLS, there was a whole structure of rules. I mean, there's been a whole section of the MLS rules and regulations that have been deleted as a result of the settlement. And it defined what an offer of compensation was, what it had to be, what it didn't have to be. Are
Correct.
you making an actual offer of compensation by putting it on your website, or are you merely telling buyer's agents that you're inviting an offer to request this amount, that you've been authorized by your seller to offer this? Because let's say that, let me pick a number out of thin air, just a made up number that says you're authorized by your seller to offer 50%, 50% commission. But I'm a buyer broker, and my agency contract is for 35%. So now I can't accept your 50% offer. I can only take 35. So, or are you in a, maybe it's not a unilateral offer of compensation.
Yeah.
So what this has done is it's taken something that was pretty stable, often misunderstood, but but not in practice.
But what I would say to that is this: how many people were being honest and going, hey, I'm at Y, you're offering X, I can't take X, I can only take Y.
It's happening. I'm aware.
Now,
Now it is. Before it wasn't, because before you were always authorized to take whatever the listing broker was offering. I mean, that was in the PAR buyer agency contract. Our policy is to accept whatever the listing agent is offering, but we won't take less than, and then you fill in whatever the number is. Um,
correct.
and there you had, at least you knew what your minimum was, but you could always make more. Now the dynamic has shifted. And so what realtors need to be cognizant of is, depending on how and who relative to your fee as a buyer broker.
Mhm.
How am I negotiating it? You have to be very cognizant of that because you could walk into an ethical quagmire, capital E ethics, meaning code of ethics, quagmire
Mhm.
on how you do that. You're going to have a lot of misunderstanding, I think, from agents and realtors, because there has been a lot of discussion over the last, where are we now, 5 months, 5.5 months since the settlement was announced, March 15, and just expecting that putting out there on a website, on my socials, on the flyers, on a rider, on a for sale sign, that I put a percentage that I'm offering as a listing side that's exactly the same as the way it was in an MLS. And I'm not sure that it is. And I am sure that it hasn't been thoroughly explored and vetted.
And I would agree with that sentiment. I think that too often people are so quick to jump and feel like, "Oh, I can figure this out." But have you actually truly looked into all implications to yourself, to your brokerage? And then the next thing that I would say is, and a lot of this does fall on the broker, and I apologize, but agents, you shouldn't be making decisions like that without checking with the broker first. And broker, you should be watching your agents close enough that you can go, "Wait a second, why did you do this? You never asked me," kind of conversation.
Right. So, one of the questions that I've had asked of me, coming back to, can we as agents put in the agreement of sale our compensation? And let's start with yes, but put an asterisk or make it a yes, but I'm staying away from that tally that you like to run of the it
Mhm,
depenses.
mhm.
Uh, so yes, but let's figure out what you're talking about and how you're talking about doing it. And first is, when we put it in the agreement of sale as a buyer's agent, who's paying your fee? If you're using paragraph 3A of the standard agreement of sale that Pennsylvania Association of Realtors puts out, then you're asking the seller to pay the buyer broker directly on behalf of the buyer. No problems, and it does not implicate the code of ethics.
And I think the key word though there is on behalf of the buyer.
Correct. Correct. So if that's what you're using and to put your fee in the contract, then that is as safe as you can be right now with things still a little bit in flux. I think it's going to be safe for a long time. I think it's always been a safe way to do it. It just wasn't the way people, quote unquote, always did it. Most ridiculous reason to justify behavior. This is the way we've always done it. Um, and to approach your compensation that way now is, I think, borderline irresponsible, borderline unethical, borderline unlawful. So I think you need to really reconsider that. Now, if I'm going to put my offer of compensation in the contract that I want the listing broker to pay me and put that in the agreement of sale, can I do that? Well, it's a tough question to ask a lawyer because you're asking me, is it possible? Yes, it's not unlawful to do that. Um, the way I've seen people want to do it is, I want to attach as an exhibit the CBC. Well, okay, this is where the code of ethics comes into play.
And it comes into play because if that was not in the listing contract, now I'm forcing them to change a contract that I don't have authority to be forcing that change, correct?
Well, that's the one argument. That's an accurate statement of the one argument. The flip side to that, though, if I'm a buyer's broker, my answer is, I have no idea what your listing contract says or it doesn't say. I'm not requiring you to change anything. It's a term of the offer. Well, Article 16 says you can't use a term of an offer to require that. And so my answer is, yeah, but when we had the MLS, I knew what your offer was. And now,
Correct.
and now, Nick, you're not publishing it anywhere. Or Nick, I called you and you didn't get back to me, and I had to submit the offer. So the change in the dynamic, if I want to do it the way I've always done it and use the CBC or another broker to broker fee agreement.
Pick up the phone and call.
Yeah, but the problem there is, that's a great idea, but the problem there is, some national studies have shown it takes a listing broker 36 hours, a day and a half to return a call. So my question becomes, are you able now as a buyer broker, are you able to wait for the listing agent to get back to you and answer that question and still be competitive and represent your buyer's interest?
Now, I would then argue the point
Mhm.
of Article 3 if are you actually cooperating then if it's taking you 48 hours to get back to me?
And I think the answer to that is, where do we there's only one, the one place, I want to say the only place, the one place where cooperation is defined is in the MLS rules and regulation, the handbook.
Mhm.
And, Article 3 makes very clear that cooperation and compensation are unrelated. And the MLS redefined cooperation to specifically exclude any reference to compensation because it can no longer do it in the MLS.
Mhm.
So, not answering a phone call or not getting back to the phone call, the listing agent not returning the phone call in the buyer's agent's time frame, for a question about compensation, I don't think that implicates Article 3.
Okay.
Uh, Particularly now that we're not dealing with the compensation in the MLS.
Mhm.
And so how do you avoid that? How do I avoid the ethical concern? I think the easy way to avoid the ethical implications are you use paragraph 3A and you go directly to the seller and say, seller, pay this. Because now you've created a dynamic where the listing broker, if they're offering compensation, can trigger the phone call to you and say, hey, if I'm the listing broker, Nick, you submitted an offer asking my seller to pay X percent. My seller's not willing to pay anything, but I'm willing to pay you X percent.
Mhm.
Okay. So now Nick's response is great. Send me a CBC signed and amend the agreement and have your sellers initial it, and I will review it with my buyers as a counteroffer. And that's the appropriate way. That is an appropriate way. I don't want to say I don't want to make it sound like that is the only way to do it, because it's certainly not.
Yeah.
That is one way to do it where, gee, I need to use the CBC. I want to use the CBC. Why are you wanting to use the CBC? Because, it's my security blanket. It's what I've always done. Well, how
Right.
many times in your career did you use the CBC? Well, if I'm in central Pennsylvania, maybe never. Right. So what kind of a security blanket is never?
Yeah.
Um, so what do you do in a situation? What happens if if you've got a listing broker, and let's say, Nick, that your brokerage, Howard Hanna, let's say they take a position that says we are not offering or accepting compensation from brokers.
Which would be the broker's right to make that decision.
Absolutely,
Not
they
that
can do
Howard
that.
Hanna has made that decision,
Yeah.
but it is
And I'm
an
not saying that
appropriate
anyone
decision they
has.
could. Yeah.
Yeah, I'm not saying that any broker has.
Yeah.
But I'm saying, what about that? What do you do in that situation? Let's flip that scenario. So let's say now, Nick, you come to me and you say, you put in the agreement of sale that your buyer wants the seller to pay X percent directly to you, Howard Hanna.
Yep.
And I say, Nick, my seller's not willing to do it, but I'm willing to pay you. Now you say to me, yeah, but we won't accept broker to broker compensation. Now, do I have an Article 3 claim against you because now you're trying to force me to change my listing contract with my seller to reduce my fee so that my seller pays you? And I think
Mhm.
the answer to that question is no, because you don't care if you're doing your job right as a buyer's agent.
I don't care if you're walking away with the same fee that you originally had or not.
You don't care what I'm getting
It's
paid at
between
all.
him, you, and the seller.
Right. So no, you're not asking me, but there's no way my seller is going to pay my, you know, the full X percent that we negotiated plus your fee because they expected me to pay that from you. Well, then I think my argument would be, well, hang on. You told me what you're willing to get paid, and I'm not telling you to take any less than that. Rather than the seller pay you, cut you out of the deal, and pay me directly. So, it's all of these nuances are things,
Mhm.
this is the consequence, right? When you get lawyers and people that don't practice in real estate, you don't get the MLS, the lawyers that represent MLSs involved in structuring the settlement. Now you get this. and it's like spaghetti. It's like trying to figure out, do I have one strand of spaghetti or 7,000 on my plate? And so now we're in this interesting dynamic. Now NAR has said, and they talked about it when I was at the legal summit in September, that they are reviewing the articles of the Code of Ethics, and in particular several of the standards of practice, and modifying them to comport with the consequences or the expectations of the settlement agreement and how that affects practice. What are those going to look like? I'm hoping that we find out before May, before the governance meetings in May. Um, the whether we get it before then or not, NAR still does have a lot on their plate right now. They're still dealing with the finalization of the settlement and the implications of that. There's clear cooperation policy, which
Hmm.
is out on the horizon as a growing issue, and there's a lot of interesting debates about that, and misinformation out there about what the DOJ thinks or thought about clear cooperation. You've got other issues out there regarding compensation forms, listing contracts by agency contracts constructed by state associations. And what is that? So there's a lot of things going on very actively in the industry right now that has NAR's attention. It would be great to be able to say that, hey, here's what NAR is going to tell us to do vis-a-vis the code of ethics.
Yeah.
And even then, here's always the challenge, right? When you're dealing with the code of ethics, NAR doesn't tell you what the answer is.
No.
They give you the standards of practice to interpret. There are case studies,
Yep.
and as you know, and some of your listeners know, I represent two associations that handle their own. They still handle their own ethics and arbitrations. And one of the practices that we implement in those associations when there's an ethics claim is the ethics hearing panel has copies of the case interpretations for the articles at question, so that they can look at how other is the case interpretations are actual cases that have been submitted to NAR. and
Okay.
and this is how we decided it. Now, of course, the name's been changed to protect the innocent and the guilty and whatever the case may be.
Yeah.
But now, we're giving our panelists other real life cases, some of which are on point, some of which aren't. But at the end of the day, it is a panel of realtors hearing the case who make a decision as to whether or not you violated the article.
Correct.
And you can have within the same association two identical fact patterns, two different panels, and two different solutions.
Correct. And I think that, the thought process has always been, we govern ourselves, and that, has worked to a point, but we also don't have all the answers. And I think it would be smart to have, in my personal opinion, outside counsel or inside counsel be on that panel
Mhm.
to give more depth answers, thought processes, and make people's wheels turn.
And I think NAR has always taken a position to encourage that. I know when I go to, so for, gosh, I'm trying to think when this started, probably close to 10 years now ago, where NAR added a half a day before the legal summit, um, exclusively for state or local association counsel that handles professional standards, to review professional standards, to do professional standards for board counsel, talking about dealing with different issues, dealing with protecting due process rights, dealing with drafting findings and conclusions of the panel. How do you deal with what do you do if you have an attorney or you have these different situations come up with, that come up in hearings all the time? And, the benefit, of course, at NAR's level is they have a whole country to
Mhm.
draw from experiences, and they're presenting, these aren't hypothetical situations.
Yeah.
They're situations that they're drawing from. And so, yeah, that's such a great, and I think I've been to every one that NAR has offered. And there's a lot of repetitiveness. You go to, the same conference year after year after year after year. The standard forms doesn't change a lot. So there is a lot of repetition, but that's not a bad thing. It's always, even if I'm looking at the same, I remember, several of the questions that we deal with in the handouts are the
Yeah.
same questions year to year to year. That doesn't mean I'm still, that I see the same thing and now I'm getting different levels of nuance, different levels of understanding. So there's such great value in that. Um, so yes, to have that guidance of counsel is, I think, a great asset. I know it's one of the most enjoyable aspects of my job as counsel to an association because I'm constantly reminded with how serious realtors take their ethical obligations,
Mhm.
and in most, if not all, associations, serving on the local professional standards committee is one of the most sought after positions, within the association because people view it as a higher calling, if you will.
Mhm.
We expect more. And many times I've looked at a case and look at it with the eyes of a lawyer because that's what I do. And I look at something and I'm like, yeah, it's no big deal. Or I look at something like, yeah, this is pretty egregious. And a panel will see it completely differently from how I see it. And I value that because I look at that as greater teaching for me as I learn more and more about how realtors view certain fact patterns, certain scenarios. And in different, again, I've had similar fact patterns in different associations with completely different reactions, responses, and conclusions.
Mhm.
But each of them is equally supportable because of again, facts obviously matter, but how the realtors on the panel view this is important here in this part of the state. This is important over in this part of the state, and things and practice nuances are so different. Um, I find it fascinating. I find it very insightful and very helpful, and I think it's something that adds to the skill set that I bring to other associations because when we talk about these things, in your area, you might be looking that this isn't a big deal. Article 16 prohibits you from interfering with an exclusive agency relationship.
Correct.
And I remember years ago, I wasn't involved at the hearing, but there was a finding of an ethics violation of Article 16. Then the appeal was held, and I came in and I looked at it. Someone said, "Can you handle the appeal? Can you help me with the appeal?" And I looked at it, and right away I noticed. Of course, this is there were no attorneys involved at the hearing level. Board counsel's job, right? And I looked at it. I'm like, "You've got a non-exclusive buyer agency contract here. Article 16 doesn't apply at all."
Mhm.
So, going into the appeal hearing, and I mean, it was people were digging in and ready for, oh my God, you brought a lawyer. We're going to be here for half the day. And my argument was, look, Article 16 requires an exclusive agency contract. This is a non-exclusive agency contract. You need to dismiss this claim. And that was my argument. And it didn't take all of 5 minutes.
And it was dead in the
And
water.
and the whole panel, the appeal panel, looked at me, and of course at the appeal you've got the chair of the panels there, and they looked at me, and they looked at their notes, and they looked at me, and then they said whatever they said, which was off of their notes, and they said, "Do you have any other comments?" I'm like, other than to
Oh, that's
repeat
it.
that this is non-exclusive and it says exclusive? No.
Yeah.
And it was a successful appeal. Um, I've had scenarios where people have said, you're interfering because I have a listing agent, right? I'm listing a property, and I have a buyer that comes in with a buyer agent and sees the property because they've signed in and maybe we've negotiated,
Mhm.
and then the deal doesn't work out, and then now I get the buyer that comes back 3 weeks later, and
Mhm.
hey, where's your agent?
Yep.
Okay, and it's I fired my agent or my contract expired. Okay. There are some parts of Pennsylvania where the buyer stating that, or even signing off and saying that I've terminated the relationship, is enough
Mhm.
and not a violation. There are other parts of the state where panels have held the listing agent accountable for not making the call to the buyer broker and say, "Do you still have an active contract?" So
Yeah.
that's a geographic difference. And what would they do here in central Pennsylvania? It depends on the panel. So those are the fascinating things, and that's where having counsel involved can be beneficial.
Yep.
I don't ever have a say. And what the outcome is, it's not my position. I think my job as counsel is to kind of keep people on track, to what,
Squirrel.
yeah, exactly. And you know, realtors are, you'll get your, you'll get your teeth into something, and you'll want to chase that. And I've had panels that want to chase an issue, and I try to do it as gently as possible. Once or twice, I've had to call an executive session in the middle of a hearing to say, "Hey, guys, first
This
of
is
all, you
not.
can't go down. This isn't what the issue is."
Yeah,
And
you're going
and
down a rabbit hole.
and secondly, you guys are making some statements about what the law says that are incorrect.
Mhm.
Please don't do that. Don't make me, So there's the role of counsel, and that kind of stuff happens. It happens. I mean, I've been representing, I've represented realtors in ethics hearings for many years, and I've seen it happen. And I've seen attorneys that do a good job of reining the panel in. And I've seen attorneys that are more interested in playing Candy Crush or whatever's on their phone at that moment, not listening to what's going on.
Yep.
And that's when it turns into a real kerfuffle.
Yeah.
Um, so I mean, I guess to kind of loop back around to where we started, a couple things I really want to, I don't want anyone to think I'm suggesting what a policy should be or shouldn't be,
Correct.
because I'm not doing that. I always, I want to be very careful, when I make things. And, I recently had I do a lot of teaching, and, I teach in, the challenge of being an educator and an attorney is, sometimes people take what I say and they go back to their office and say, Woodburn said this.
Yeah.
And I've had over the years, I've had calls from offices, and I make very clear in the classes that, hey, I'm not your broker. And if I say do A and your broker says do B, you do
You
B
do be. Yeah.
100%. And I'm up here, I'm, your office policy is this, and that's fine. I'm not here teaching policy, and
Or
then
setting it.
correct. And then I'm not setting it right. And so I want to make sure that anybody's listening doesn't think I'm trying to set a policy. I think some key takeaways is to make sure when if you are holding on to the practice where you as a buyer's agent are expecting the listing broker to contribute towards your fee, then one important takeaway is don't ever use the offer or the terms of the offer to try to adjust that or negotiate that.
Yep.
Okay, that's just it's not that you can't do it. There are so many factors that go into play, and it's such a it depends scenario
Hmm.
that unless you really understand that and you have good guidance and good teaching, you've got more at risk on an ethical basis. Don't let the listing broker's willingness or lack of willingness, or importantly, your lack of knowing what the listing broker is or isn't going to do vis-a-vis your compensation. Don't let that ever factor into whether or not you should show a property or submit an offer.
Correct.
And honestly, if you're complying with the settlement that's in place, if you're a realtor and you're a member of an MLS that's following the NAR settlement, that means you are getting a written agreement with a buyer that establishes your fee. So once you've done that, you're no longer beholden to a
To the
listing
seller
broker.
or list. Yep.
And it doesn't mean you can't go and ask to be paid,
Correct.
but you're no longer making those decisions. I think if you're an agent or you're an office that has used and for now wants to continue to use the CBC, I think it's really incumbent upon you to take time to really read the CBC and understand what it says, what it does, what it doesn't do, how it establishes how and when you get paid. Um, I've had hundreds. I've been in front of hundreds of realtors since March. I've talked about the PAR forms. You know, I've been critical, not necessarily in a negative way, but part of my job when I'm teaching something is to identify challenges. There's a lot of good things that I point out that people don't realize that I think are excellent parts of the form. So, and too many people focus on the negative aspect of a criticism. I don't mean it that way, but you need to critically think. You need to read it and not presume that the form says what somebody tells you it says. whether that somebody is me, whether that somebody is PAR, whether that somebody is your broker. I think it's incumbent upon you as an individual to read it and understand it so that you know what the tool is and what it's designed to do. Are you using a chisel or are you using a sledgehammer? And not understanding a form may turn it into a sledgehammer when it's really designed to be a chisel. When you are negotiating as a buyer's agent, when you are trying to negotiate your compensation with the listing broker, I think it is really important before you go down that path of initiating those conversations that you understand the limitations, restrictions, expectations that the code of ethics puts on you, because that's gotten lost in a lot of ways, or been overshadowed. Maybe lost isn't the right word, been overshadowed by the change in how the practice is working.
Yep.
And because if your practice was reliant upon, if your compensation, if you were relying largely upon what the MLS was making available to you, now you can't. You don't have that skill set. You've never trained that skill set,
Mm-hmm.
and you've never had to consider the different factors that weigh into it. So understand that they exist. Understand that the standards of practice as they exist today, as we're recording this, and how they might exist in 2025,
Mm-hmm.
maybe not even until late 2025, or might be different.
Then yeah.
And also appreciate that the decision as to whether or not you violated the code of ethics is made by a panel of your peers. So you have a couple of balancing acts that are impossible to do well. One is the practical aspect of how do I practice real estate compliant with the law, the settlement, and the code of ethics. The other is the reality of the practice in your area where you're media,
Where
where
you're
you're hearing this.
practicing.
Because, you might end up, I know, Nick, I know you practice in areas where there's more, with in front of different associations. You're
Yes.
not always within Greater Harrisburg Association of Realtors. You sell property that a hearing could take place. Either you as a complainant or a respondent could be in a different association.
Yep. It could be York, Lancaster, Philadelphia, Poconos. I mean, you're
Right.
right.
And so you want to appreciate that how they do things in the Poconos, how they do things in Luzerne, how they do things in Lancaster, how they do things in York is going to be different than how they do things in
Drastically different some places.
yes. So your expectation of what's acceptable, or your understanding of what is very acceptable and not an ethics concern
Mm-hmm.
in Harrisburg may be a big concern in the Poconos.
Correct.
And what you view as an ethics concern here in Harrisburg may be common practice in Luzerne County or some of the other counties that you go into. And I'm not, not picking on
You're not
anyone.
picking on
No.
any certain association or
And
area exactly.
yeah, and it makes it
And
hard.
it does, but I think, because I do it and I do it phenomenally. Or at least that's what my reviews say. Um but I think a lot of that has to do with the fact of the relationships that I've built across the state and the relationships that I have, that at any point in time I have probably a handful of people in each location that I choose to practice to pick up the phone and say, is this normal for you?
Yeah,
Because if it's not, I need to know, and if it is, great, I'll back down and shut up,
right.
which doesn't happen often. uh,
Even when you need to. No. Yeah, and I think it's one of the challenging things of being a realtor,
Mhm.
but it's also one of the aspects that sets you apart and above
It
the
is.
competition.
Yeah.
And I think that for as frightening, as overwhelming, as uncomfortable as these practice changes are, as the relevance for articles and standards of practice under the code of ethics, which you haven't really had to worry about very much, are now becoming very relevant. It creates an environment where growth can really happen, personal growth, professional growth, where you can become better at what you do and how you do it, because now you're being forced to study aspects of your profession. If you For those of you that consider being a realtor a profession, this is now an opportunity to study your profession at a different level from a different aspect, a different perspective.
Different mindset.
Absolutely. And gives you a great
Correct.
opportunity to capture different market share.
It is. Well, Brad, as always, it has been a pleasure and an insight. I don't think people give enough recognition to the attorneys. You know, people hear the word attorney and they cringe, but I think that used correctly,
Mhm.
attorneys are very
Yeah.
useful and can bring a whole new thought process to things. And I know our viewers really love hearing from you. So,
Well, thanks. I
as
heard,
always, a pleasure.
I appreciate that. And, I heard someone on a podcast recently talk about the role of an attorney. And this was in a real estate brokerage environment. And the particular person
Was the
speaking,
role being rolled over or
no,
oh, okay.
it was actually, I appreciate, I didn't entirely agree with the perspective, but I appreciated it.
Shocker.
Well, and I'll tell you why in a second. But they talked about the value of attorneys and the importance of having them in the room, particularly when you're making decisions and policy decisions, because it's their job as an attorney to identify where the guardrails are,
Mhm.
so that you don't. If you're going to break through the guardrail, you're doing it knowingly and likely against legal advice.
Mhm.
But they also said that the attorneys shouldn't be running the making the decisions, because you'll suffer from paralysis by analysis.
Correct.
And that was an area where I slightly disagreed with it. And I said, well, that depends on it. Here it comes here. It depends
I
on
think
the
we're at like 6 for this
right.
one alone.
I know, and the attorney that's in the room,
Mhm.
and what their understanding is and their role is, and
And you
you
know
will
what though? You said it for the professional standards panels. And you know what? I think it truly goes to any industry and it is the truth. If you have everybody that is in the room and they're all agreeable, you don't have the right room.
correct.
You need to have professional arguments and disagreements on things because that is what makes things better.
Absolutely. Absolutely. And that's how everybody learns.
Correct. So, well, thank you, Brett.
Thanks, Dick.